call our meeting to order. I have a list of things to talk about with you. Since we invited you, unless you have something you'd like to start with, I'll just get right into those. I think other committee members do as well.
I think it'd be safe just to jump right into it, and I'll answer my questions the best you can. Evan Meenan, Associate General Counsel for the Natural Resources Board. And Diane Snelling, Chair of the Board, sends her apologies, but the weather prohibited her from being here today.
Thank you for being here today. I think what would be helpful for us as we have contemplated different ways of restructuring the board, it would be helpful to just hear you walk us through the process, and then we'll ask you questions along the way. So
Okay.
I am a developer, and I walk into, like, what do? I think I need an Act 250 permit.
Okay.
It's like a first aid scenario.
The triage?
I'm a developer, I think I need a permit.
Is that a date you really want to go?
Yeah.
I think I'm still breathing.
Okay.
I'm not sure. When I look at the CO2 levels in the room, I'm really not sure actually.
Sure, I can sort of walk through the general process. I'll also say, and Diane wanted to make sure that I pointed this out, we have brochures, we bring them on every road show that we go. I've got multiple copies of them for all the committee members and probably some leftovers for people in the room. It has a flow chart that describes the process, start to finish, of exactly what people can expect. I think that these have been submitted to the commission before, but if not, I will pass them around now so that people can have access to them. In an ideal world, though, hopefully the process would start even before the first entry on this pamphlet. The first entry on the pamphlet is step 1, contact your district coordinator. Before that happens, the savvy developers, including folks like Ernie Pomelo, have probably already reached out to other regulatory agencies, including the Agency of Agriculture, ANR, the Department of Historic Preservation, and they've probably also reached out to neighbors as well to gauge how well their proposed project will be received, identify preliminary problems that people might have, and then readjust their plans accordingly.
This is assuming they already know they are under jurisdiction. Let's go for, I need a jurisdictional opinion.
Sure. So if someone is not sure whether or not they need an Act 250 permit, the easiest thing for them to do is to contact the district coordinator. The names, contact information, office locations, and office hours are all available on the board's website. During that initial consultation, what they'll likely do is sit down with some type of preliminary description or site plan of their project. The coordinator can provide them some initial feedback on things like jurisdiction and potential problems with the project. But ultimately, if there are basically 2 options after that, or 3 really. One, the coordinator is just going to say right there, without the need for a jurisdictional opinion, you don't trigger jurisdiction. Good luck with your project. All the best. Or the coordinator could say, I think that there's jurisdiction over your project. If you want a definitive opinion, you can request a jurisdictional opinion from me, and I will answer it as soon as possible. Or you could just apply for a permit. And then the third option, obviously, is the person just applies for the permit. If there is a jurisdictional opinion, then what they do is they submit information to the coordinator, usually a preliminary site plan and a general description of their project. I should actually go back. There's 2 different forms that a JO can take place. The first is the sort of formal process where you submit that information I just mentioned. The coordinator may have some questions, and there may be a back and forth dialogue that occurs in person, over the phone, but typically email. And then there's a formal jurisdictional opinion that's issued. Sometimes they're as short as 1 page, sometimes they're pretty lengthy. I think I saw one the other day that was like 6 or 7 pages. Related to a trails project. So,
We have questions about that one.
I'm sure you do.
How might you do that?
The other form that a jurisdictional opinion can take is it's called a project review sheet. And so what that is the Agency of Natural Resources has permit specialists. And what you can do is you can fill out a form if you're a project developer, submit it to one of these permit specialists, and then the specialist attempts to identify all of the different state permits that you might need to obtain for your project. One line item is an Act 250 permit, and so what the permit specialist does is it shoots out a copy of the project review sheet with a description of the project to the coordinator. The coordinator reviews it and just fills out the section of the review sheet that says, do you need an Act 250 permit? And that is a jurisdictional opinion.
From the permit specialist?
From the coordinator actually signs it.
Okay.
So
the permit specialist follows that question?
exactly,
Okay.
there's some collaboration there.
The district coordinator signs it?
Yeah, so the permit specialist will sign it because there's tons of stuff on there, tons of different state permits that are referenced. Only one of them is an Act 250 permit. But for that one little block on the form, the district coordinator actually signs it. So that is an official jurisdictional opinion. If someone is, yeah, absolutely.
Does that take in 250, A&R as well?
Yeah, so the permit specialists are A&R employees,
Yeah.
so there's boxes for, do you need a stormwater permit, or a wetlands permit, or an air quality control permit, stuff like that.
What if that goes away,
What do you mean goes away?
that there aren't any permit specialists? I know that the agency's going through rethinking
Oh.
that role.
Well, then that option for obtaining a jurisdictional opinion would go away, and it would just be someone would have to disclose to the coordinator enough information for the coordinator to render opinion, and they would type it up. For the easy ones that you would typically see resolved through a project review sheet, it would probably just be a 1 to 2 page letter, including signature blocks and captions and stuff. For the more robust ones, it would be like a pretty robust written work product.
Thank you.
Yeah. So if someone gets a project review sheet and it says no jurisdiction, then best of luck to them. They move on with their project. If it says that they do need to get an Act 250 permit, then one of two things is going to happen. They will say, okay, fine, and prepare an application and submit it, or they will be upset, take the position that they disagree with the jurisdictional opinion, and then they will do one of two things. They can ask the coordinator to reconsider their decision. It's the same exact coordinator who wrote the original opinion that does the reconsideration. I read another one of those, again, Trails yesterday. And then, and if they're still unhappy with the reconsidered decision, or if they just want to skip that process because it's not mandatory, they can just straight appeal the jurisdictional opinion to the environmental court.
How long does that take?
The appeal process?
If you go to the environmental court?
Well, that theoretically could take just as long as any other appeal before the court. I mean, I think the court has their own performance standards for when they like to see appeals resolved in the environmental division. I think that the court administrator presented some data on how frequently they meet those performance standards. My recollection is that they're pretty darn good about it, but you know, you could go back and refer to your own record for that point. I will say that while someone is appealing a jurisdictional opinion, they can simultaneously apply for their permit. They can navigate both processes simultaneously, and if they choose to apply for a permit while contesting the JO, that's not considered to be an admission to jurisdiction. It's well established that people can do both things at the same time. To hopefully speed up the process. Maybe they realize Act 250 is not as bad as some people say, and they drop the JO appeal because they get their permit. Who knows, right? So after, so we already made it through the entire left-hand side of this pamphlet, which is pretty good. We're moving a lot quicker with less questions than I thought. So after,
I do have a question.
okay.
And maybe you'll get to this later. How do you decide between a minor and a major?
Right, okay, so we are gonna get to that.
Okay.
Very, very soon, actually. So
I have one question.
Yes.
On the jurisdictional opinion, if that's appealed, that would be appealed on legal grounds solely?
Well, no, like all other appeals, it's de novo. So the court takes a fresh look at it, just like the coordinator did originally. So it's theoretically possible that the project developer could appeal the JO, and then once they get in front of the judge, present a bunch of additional information or data that they didn't present to the coordinator. And it's even possible that if the coordinator had all that information, they could have reached an opposite conclusion. So that's why, because of this de novo standard of review, when the court reaches a different decision than a coordinator or a commission, it's not necessarily a ruling that the commission or the coordinator got it wrong. It could be that someone did something new or different or had additional data that is meaningful.
They could have changed it.
Yeah, they could have changed it. So that, that's another reason. And just because the court reverses a permit decision or a JO doesn't mean that the person got it wrong. It just means that something might have changed that rightly leads to a different conclusion. Which is why, for example, and I'm getting off on a tangent here a bit, but which is why sometimes the Natural Resources Board will actually settle an appeal that in a way that reaches a conclusion that's different than the one that a district commission reached. We monitor all of the appeals, and we might say, wow, that actually makes a difference. That should lead to a different result, and we're not afraid of admitting that to people. So picking back up on the process, once it's established that someone is going to apply for an Act 250 application, they fill out the application, and we're in the process of developing a new online one, and submit all of their supplemental information and evidence. And then what the coordinator sees it first, and they make an initial decision about whether or not the application is complete or incomplete. If they decide that the application is incomplete, by statute, that is deemed to be a jurisdictional opinion, and that incomplete determination can be appealed to the environmental court, just like any other act or decision. If the application is deemed complete, then the commission has the responsibility for deciding whether or not it's going to be a major application or a minor application or an administrative amendment. And both this pamphlet that I provided to you, as well as the last version of the board's annual report, provides a breakdown of all the applications, but roughly 40% of all the applications are treated as administrative amendments, 45% of them are treated as minors, and only 15% are majors. So a small portion of them are treated as major applications. It is the commission that has the responsibility for deciding which of those three processes will apply. They do consult with the coordinator, though, in making their decision, and they have access to the coordinator for advice. They also have access to the two NRB staff attorneys for advice. If the commission decides that it's going to be an administrative amendment, and that's really for like record-keeping purposes, where there aren't any major substantive issues that need to be resolved. A classic example would be something like, someone has an Act 250 permit for a car dealership, and they update their stormwater infrastructure, and they get a stormwater permit that's entitled to a presumption from A&R, and all we need to do on Act 250 end is incorporate the terms of the stormwater permit into the Act 250 permit. That's like a classic example of something that could be resolved through an administrative amendment, just updating the paperwork so everybody knows what the current requirements of ancillary permits are. A major application is the next sort of clear thing to explain. But a major application is one in which the commission concludes, based on its own review of the application, or comments received by a statutory party or a member of the public looking for party status, that there may be a substantial issue under one of the Act 250 criteria, and that additional evidence, testimony, and legal briefing is necessary to resolve that issue. Everything else falls in the middle, the minor applications. In other words, it's not a paperwork problem, but there's no real contested issues under the criteria. In other words, the applicant did a pretty darn good job. They collected all of the information and evidence that's relevant to the commission's decision, and it's really just a matter of reviewing it to make sure there's no issues. If
I might have, I just want to go back to the major.
Yes.
Just what you, I missed what you said about it.
Yeah, so the major applications are the ones in which, and let's see, there's a rule about it. Yeah, so Rule 51, Act 250 Rule 51 is the procedures that have to be followed when something is going to be processed as a minor. And what it says is,
As a minor?
as a minor.
It's the flip side of the
Right,
measure.
right, exactly. But it's easier to look at the definition of what a minor is and then by exclusion realize what a major is. So it says, a minor, something can be considered as a minor if the district commission determines there is a demonstrable likelihood that the project will not present significant adverse impacts under the Act 250 criteria. So that's the standard, significant adverse impacts.
So this is an application that's addressed all 10 criteria and demonstrated to the, whatever, to the district commission that it won't have significant adverse.
That's right. We've got all our ducks in the row. All of our ancillary A&R permits, we've got them. We have our municipal impact questionnaire done, school impact questionnaire done, all of our wetlands delineations. We did, we did everything we've got to get.
And this is 45% of applications.
Yes.
And under the joint proposal, they're saying, no, that the district commissioner should just, or do this. The district coordinator.
Yes, that's right. So the joint proposal has the coordinators issuing minors instead of commissions. Now, so the process, so let's just assume that the commission decides it's going to hear a minor case because there's no significant issues. What'll end up happening typically is the coordinator will, send out the application materials to the commission members. The commission members are expected to review them, and they do. And then if the commissioners have any questions or concerns or things they would like to see in a permit, they relay that information back to the coordinator. The coordinator develops or writes a draft permit, types it up, and there's usually a back and forth exchange that occurs over email between the coordinator and the commissioners to flush out the language in the draft permit. And then the draft permit is sent out to statutory parties and adjoiners for public comment. And at that point in time, if any of those people think that there is the potential for a significant adverse impact under the criteria, they can request that the case be converted into a major application for the purposes of holding a hearing.
And so under the joint proposal, that would all of a sudden mean you've started this process locally, and then it's gonna become, this joint, or this board's gonna come in and hold the first hearing.
Yeah, so how it would happen under the joint proposal is that the coordinator would basically draft their minor permit, proposed permit, like they do now. They would send it out for public comment, and if when they get public comments, what would likely end up happening is the coordinator would send the comments to the enhanced NRB.
But comments don't trigger major.
No, it's not just the comments. In other words, a commission can look at the comments and say, thank you very much for your feedback, but we actually don't think that you've raised a significant issue under the criteria, so we respect your opinion, but we're not going to hold a hearing. This is going to stay a minor, and we're going to issue the permit. So under the joint proposal, since it's the board that would decide, are we going to convert this to a major, or is this going to stay a minor? And if the decision is to convert it to a major, then the board would hear it, the three, statewide full-time members and then the two regional reps. And it would be out of the hands of the coordinators.
Jim?
There's a nuance here that I'm not quite understanding.
Okay?
I'm thinking in the joint proposal, it's the enhanced board that makes a decision whether it's a major
Yes, that's
or
right.
a minor.
That's exactly right.
Which is a little different than what I'm just hearing. What I think I just heard was, if the district coordinator and commission agree it's a minor, and others disagree, then the enhanced board will make a call.
Okay, so I'll explain it, how it exists right now, and then I'll revisit how it would work. So right now, the coordinator gets the application, he or she reviews it, and so do all the commission members. The coordinator, in most situations, will make a recommendation to the commission members, hey, I think this should be an administrative amendment, or hey, I think it should be a minor, or hey, I think it should be a major.
Yep.
And the commission, though, ultimately makes the decision.
Yep.
Now, if the commission decides we would like to treat this as a minor, and someone submits comments, the commission gets to revisit its initial decision in light of those comments. So it could decide, you know what, that neighbor raised a really good point about traffic, we better have a hearing on this, we're gonna convert it to a major. That's how things work right now.
Yep.
Under the new proposal, under the joint proposal, it would basically function the exact same, except just replace the commission with the enhanced board. So the coordinator
In that decision to go from minor to major.
That's right. So the coordinator and the board would still review the application. The coordinator would likely make a recommendation for if it should be a minor or a major or an AA. The board would ultimately be the decision maker.
Yeah.
And if they decide, let's treat this as an AA, and then it receives comments, the board can always change its mind and say, you know what, coordinator, we don't want you issuing this as a minor. We're gonna pick it up from here, thank you for your work, and we're gonna hold a hearing and treat it as a major.
And I think that's sort of the subtle difference. What I think I just heard you say is, if the three-member board thinks it should be a major, it'll be a major.
Yes, yes. Well,
Which takes,
it would be the
without appeals.
the regional, I mean.
That's what I meant.
Yeah, the two
enhanced-
regional people would, well, that's not clear to me under the joint proposal. I don't know if the joint proposal really addresses that specific question, whether or not the two regional members would have a voice in how it's treated.
Yeah, and so it'd be, and when I said three-member board, I should have
Yeah.
been more explicit. The enhanced NRB will be the one making the call.
Yes, that's right.
Whether if it's going to become a major.
That's right, and I don't recall whether or not the joint proposal specifies if the two regional representatives would get a vote on that issue.
Yeah.
I'm not sure about that, but
We'll take care of
that's
that.
I'm sure you're all over it. But, okay, so what that conversation just covered is one of the big differences between a major and a minor, and that is, are we gonna have a hearing on this thing, or is it really just gonna be notice, comment, and issuance? The second major difference relates to what types of appeals are available. So if there is a minor permit that is issued, I should phrase it differently, I guess. The way that the statutes and rules read right now is, you can't appeal unless there was a hearing, which means it was a major, or you requested a hearing and one was not held. So in other words, if I see that there's a minor permit that's been posted for public notice, and I file a comment that says, this is the worst project ever and we need a hearing, and the commission says, I disagree with you, we're not gonna have a hearing, I can at that point appeal. That's something that I can appeal. But if I did not request a hearing, then I'm out of luck.
And who can request a hearing?
Anybody. So what you'll normally see
You
is.
don't have to have You don't have to have standing.
Well, so the way that it normally works is someone will usually what will happen is someone will simultaneously submit comments that request party status and ask for a hearing. Sometimes people forget that second part and just ask for party status, and coordinators are typically pretty good at saying, we just got your request for party status, we noticed that you didn't request a hearing, are you also doing that? I just saw, for example, Bill Burke did that like last week or the week before with someone, and they were like, oh, thanks for pointing that out, yes, we want a hearing. I don't know that they're ultimately gonna get one, but.
Form, in my opinion.
I have a question when you say
Well-
you just saw, where are you seeing how folks are making these decisions? Is
It's
there a-
usually you can submit it via email if you really wanted to. You could email the coordinator and say, hey, I just saw that, you know, this permit was posted for notice, I've got real issues with it.
No, I mean you.
Oh, me?
I'm wondering about just
Oh.
within the organization.
Oh, it's when like a commission or a coordinator reaches out for legal advice. Yeah, and then we review the file and do the best we can. So those are the two big differences. The degree to which you can appeal and whether or not there's a hearing.
I got the hearing part, the appeals, you said what exists now.
Yeah.
What was the new way? Anything?
It would be the same, it would be
Oh.
unaffected.
So the two main issues are the appeals and the other, all right.
Right. So, after the permitting process in front of the commission is complete, which means either the permit's going to be denied, and there's some statistics in our last annual report. I think we had, I think it was under 5 denials out of 400 some odd applications, something like that. I can look up the number
Last
if you
year.
really want. Yeah, it's 2018. But it is in the annual report. Our annual report has a couple tables that break all that down. So you're either going to be denied a permit, or you'll be issued a permit, typically with some type of conditions attached to it, and those conditions appear right in the permit itself. And if in order to appeal that, you have to have been granted party status. In order to appeal the permit itself, you have to have been granted party status. You can always appeal the denial of party status, but in order to get at the merits of the permit decision, you need to have been a party. There's certain statutory parties, and then anybody who demonstrates that they have a particularized interest that may be impacted and is protected by any one of the Act 250 criteria, they get party status. That's the standard. So, hey, this car dealership is putting in a new parking lot, and I think all that stormwater is going to flow onto my property and not be properly treated. You're probably going to get party status, something like that. So those get appealed, and those appeals go up to the environmental court. The environmental court, absent a settlement amongst the parties, will eventually hold a trial and issue a written decision. The environmental court conducts its review de novo, which means there's no deference given to the commission's findings of facts and no deference given to the commission's conclusions of law. The entire thing is though it never happened.
Which is something many seem to agree isn't quite right.
You know, that it's, for many years I was a prosecutor, a criminal prosecutor at the Attorney General's office. If you take away like habeas corpus petitions and stuff like that, and you're convicted of murder, you get one appeal, and it goes right to the Vermont Supreme Court. And the Vermont Supreme Court reviews what happens in the trial. It gives deference to findings of fact, and it reviews conclusions of law de novo. If you want to put in a Dollar General in the state of Vermont, you get a whole nother level of appeal than that murder defendant, and you get to start the whole thing brand new. I think you could question who we should be providing the process to.
So, back to my first date now.
You know? So,
Whoa.
That's pretty good.
but yeah, the environmental court starts brand new,
Yeah.
issues a written decision, and then that decision can ultimately be appealed to the Vermont Supreme Court. And at that point in time, it does not start all over brand new. The Vermont Supreme Court reviews the trial court's findings of fact for clear error. It gives deference to them. And then it only reviews the legal conclusions brand new.
So that's one of the options we've been sort of kicking around with having the district commission decisions be considered that same way, regardless of the next level of appeal, whether it's directly to the environmental court like it is today. But let's just say under that scenario, directly keeping that same kind of line of appeal,
Yep.
but having it be the findings of fact and the decision be considered. How would that change? Would that speed things up?
Arguably, it would speed things up. I mean, if you're eliminating the need to redo things all over again in front of the environmental court, yeah, there's the potential to save a lot of time. I mean, some appeals last over a year in front of the Vermont Supreme Court. Many don't, but some do. But again, only 15% of the cases are majors anyway, and I think in 2018 we had 8 appeals to the Vermont. 6? Yeah,
Under 10.
Yeah. So, I mean, it's not a lot of appeals that go to the Vermont Environmental Division, but the ones that do are important to the people involved. And, the de novo standard does cause them to have to present all of their same evidence again and call in all their expert witnesses again and pay those folks. And you've heard a lot of testimony that some people think there's a lot of value to that, and you've heard testimony that some people think it's perhaps not as efficient as it could be.
Yeah, and so could that happen without going on the record at the district commission level?
Well,
Because the findings of fact are submitted as an application.
Yeah.
And then found to be their finding that's written down.
Right.
Based on evidence that's been presented.
that's right. I mean, I think in order to make the commissions go on the record, most of the changes that would have to be made are procedural changes. We'd have to get some more robust recording equipment. I don't know that it necessarily has to be video recorded. None of the criminal trials I ever handled were recorded by anyone other than the media. The judiciary doesn't video record all witness testimony. It's all audio recorded and then transcribed afterwards. So we would need to make sure we could properly audio record things. We already do audio record hearings now, but we would want to incorporate some redundancies just in case something happened with the technology. We'd also probably at a minimum have to have a contract with a court reporter to make sure that we could get the transcripts made and sent up to the Vermont Supreme Court. We would have to give some of the commissioners some more robust training.
But you're talking about if we go on the record. I'm asking,
exactly.
We've gotten one outline of a suggestion that would sort of be a hybrid that was on the record like you would video it.
Yeah,
and
I
then
think
have the findings of fact be considered in appeal.
as a practical matter, these procedural improvements that we would have to make would have to get made anyway. They just would. I mean, we would need to make sure they were all audio recorded. We already do train commissioners on evidentiary issues. They would probably need more training. It would be really beneficial to have an attorney present during those hearings to make sure that if the commission ever had a tricky evidence issue, like one of privilege maybe, attorney-client privilege, something like that, they could take a break and get the advice of an attorney. And then we would probably have to make sure that they're a little bit more regimented, kind of like how things occur here, right? Every speaker would have to be clearly identified. People would really have to make sure not to talk over one another. No uh-uhs and yeahs, yes or no. No head shakes and nods. I mean, things would have to be run a little bit more regimented, but we've got smart commissioners. I think they could handle it. But there'd be growing pains, no doubt about that, just like with any change.
So as it stands now, the NRB does not make any kind of ruling on whether something should go forward simply on record, or whether there was evidence that was left out that should have been admitted, and then say this part has to be de novo.
No, yeah, that's right. The board does not have the authority to direct the commissions on how to conduct their proceedings or how to rule in individual permitting.
Would there be a conflict if it did?
There could, I think you would hear some people argue that the commissions would be less independent and that more things might be occurring sort of behind the veil, so to speak. So you could hear that criticism.
We heard testimony yesterday that the way to make the district commission function better would be to strengthen the NRB. That's where we should start. And my own interpretation of that was also to provide the district commission with an attorney so that they would have someone there to answer those kind of questions you just raised. So that if it was on the record, that would have been, that kind of a question would have been settled before anything else went further, as far as a technical point.
Well, I'm an attorney, so I think attorneys are great, and and I think we add a lot of value. We try and go to the major hearings, but honestly, we can't get to all of them. We can't get to most of them. When we do go, I think we do add value, and we offer advice, both during deliberations and during breaks on issues of all sorts. But we can't be there for all of them, and part of that's because, we're working on the back end in the appeals after the fact, right? And that's where the board has a say in some of those issues. In other words, if we realize the commission reached a decision that was wrong, the board's authority is not to tell the commission what to do, but just to try and fix it in the appeal some way.
We've also taken testimony, actually from all sides of this issue, that you guys used to have 4 attorneys, now you have 2. I mean, in either scenario, it seems like we're gonna end up with 4 attorneys. But, I don't know, were you there when there were more attorneys than 2?
No, I showed up when there was just 2.
Do you need more capacity now?
I think what we do pretty good. It's just the volume. It's a volume issue, right?
That's why I'm asking.
Yeah,
Is the volume off right now for enforcement and appeals and supporting district commissions.
That's difficult to answer. I mean, if either the board or the legislature were to decide we want an attorney in the room for all major hearings, we would not be able to do that currently unless we gave up doing something else. That's probably the best that I can answer it. But no one has directed us to do that. When time permits, we just do it of our own volition because we see the value.
Jim, and then you.
Yeah, and so Evan, my question is really part of maybe the next step for the chair's question. In the enhanced NRB model, will those 3 professionals, we're calling them professionals, be able to cover the state, to do the job that they're supposed to do, which is go to our kitchens at home, if you will, and hear testimony and participate in decision making? Are 3 enough? And that's really quite tightly related to where you are in the NRB right now, I'm thinking. So,
Yeah.
Do you have an opinion on that?
I think the board chair thought that hitting the road for every hearing might be somewhat difficult, which is why I think there's an option in the joint proposal that parties could waive that if they wanted to. No one would force them to, but the giant road show might be a little difficult to do. But she felt pretty confident that given the number of majors that we see right now, a board of 5 people, even with 2 of them rotating, could handle that a volume of permit decisions if it had the the administrative and legal support that it needed. Yeah.
Well, it's essentially one more person than you got now.
Right. Yeah.
And okay, that's
So
an answer.
I think we could handle it. I think we could handle it.
The added criteria we're seeing now, especially what comes to mind, is climate change. Do you foresee more work? Especially more applications now being moved into major, and consequently a greater need no matter what. The NRB kind of beefing up with the legal staff, and also the commission having to have more legal assistance during these hearings.
I guess the short answer is yes. I mean, anytime a criteria is added, it's something else that has to be reviewed. It won't necessarily be terribly relevant in every proceeding, but it's another box that you need to look at. So yes, every time a criteria is added, that's more work to be done. Every time there's a change in every time there's a new jurisdictional trigger, that's also more work that has to be done. But when the board chair was looking at the joint proposal, I think as I mentioned the other day, the preliminary estimate was, 2 more attorneys, obviously the increase in paid board members, and possibly some type of clerk position to sort of handle the day-to-day administrative running of the office. Is there the possibility that we might be able to consolidate some administrative positions so we don't actually need like a new position number? Maybe, but we're not banking on that, being able to repurpose positions. So, we would need more positions because there's going to be more work.
Just to take that a step further, does it make sense at all that then the NRB, if you strengthen the NRB, then it would be, provide one of its attorneys to whatever district commission is hearing a major?
Yes, that would be possible. So, for example, if the legislature were to decide, hey, we want the board to hear majors and we want the commission to hear minors or something like that, whatever.
That's not my question.
Okay.
My
Well,
question.
I'd like to hear the answer to that.
Well, okay, yeah, but you can go ahead then, you can answer.
I imagine it would work similar to the way in which it used to work under the old environmental board, which is an attorney would still be ready, willing, and able to help the commissions, but if the matter was ever then kicked to the board, a new attorney would work on that matter. So there'd be a little bit of a division, so there's no tainting of information. But yeah, we could still, if we had more attorneys, we could still provide legal support to the commissions without sacrificing the services provided to the board.
So if we were not going to require the board to play a role in any of the appeals, so that the decision by the commission would go exactly to the Supreme Court. So basically, we're going to get rid of the E-Court, and we're going to go right to the Supreme Court as a joint provision proposal suggested. But we want that done at the commission level.
I see.
That's my question.
Okay. Yes, if that was the decision made, then I imagine that the attorneys would spend a lot less time working on appeals because the Vermont Attorney General's office represents state agencies in front of the Vermont Supreme Court, and they've got a bunch of attorneys in the environmental division. So our time would be, we wouldn't have to spend as much time on appeals, and we could rededicate that time towards providing legal services directly to commissions. We would be able to do that.
So I have a question about your roadshow comment, and you said that they could agree to waive the board coming to their region. Who's they? Like, do both, anyone with party status and the applicant would have to agree, and is that appealable, and is that another level of, delay?
Yeah, my recollection is that it's all of the parties that would have to agree to it. I believe that's the way it's set up.
Billy Coster, Agency of Natural Resources. I don't recall the specifics of that provision, but I'll say that is not our intent. The intent is that these hearings would be in these communities and we would resource it appropriately. So I'm not aware of the specific provision, but we're intending to build something that's going to be akin to the current district commission model. The professional board joins the regional members in the district and we'll resource it appropriately. So that's our position.
Carrie.
Thank you for being here and your clarification. My question is in regards to what's in front of us, and what I'm hearing from the time we've spent in here is that there's real value. The value of the joint proposal is the ability to appeal directly to the Supreme Court, and by which helping to free up your all's time to help better support district commissions. But I've also heard the value of having district commissions. And we have a hybrid model in front of us that looks at maintaining district commissions. We've talked about transforming the joint proposal from a 3 professional board with two from the region to a 5 with 2 from the region with equal status. As I mentioned, continuation of district commissions. Would that approach be effective at dealing with some of, we also heard is some constraints in, or tension between the district commission level and the NRB level? What we're really interested in seeing how it can function effectively together in a relationship that's mutually beneficial at the regional level and across the state.
You know, and it I'm trying to think about the best way to phrase this, but the tension problem, I'm not really entirely clear what that refers to, if I'm being honest with you. I mean, I've always been welcomed by the commissions that I volunteered to help with open arms. They're not bashful about asking me for legal advice when it occurs to them, and they don't always follow it, but that's true with every attorney. But there's always some value added there. I think every once in a while, when the board does not wholeheartedly defend a decision in an appeal, sometimes people are less than thrilled about that. But that's a really difficult thing to commit to do under a de novo standard of review. The board, has historically been open to taking different positions on appeals because different things and facts might occur and be presented. And we're mostly concerned about getting the right result as opposed to defending the result that currently exists. But honestly, that doesn't really happen too frequently where we get a lot of strong negative feedback about how we handle appeals. But sometimes it happens, and when it does, we usually just sit down and explain what happened differently and why we had to do what we did. I think under the joint proposal, the board's role in appeals would be more clearly defined, and that would probably provide both the board and the attorneys with more direction on what the expectation is for our participation in those matters, and that could be helpful. I don't know if that really answers your question, but I think it's probably the best I can do.
No, that's helpful.
My question was going to be, so as matters stand now, there's no decision there's no decision rendered as to whether or not something will continue on appeal either by on the record or by de novo. It's just simply it's de novo once it leaves the commission. Is that correct?
That's right.
Jim?
So, Evan, I'm thinking I understand. I'm going back to the major or minor decision. I'm very clear from your presentation how a minor gets decided and how it gets appealed. But I'm thinking if this is under the current and under, I think, the enhanced NRB.
Okay.
But I'm not clear on who gets the call right out of the gate if it's going to be if it's to be a major. And I'm thinking either I'm thinking you were a little shaky on that and would want to check it and get back to us, or I might have misunderstood.
No, I feel like I know pretty well how it works now and how it would work
Under the new
Yes.
ER.
Yeah.
Okay, then I need.
So
Need again.
right now, the commission makes the decision,
I got right now.
but it's willing to accept advice from attorneys and coordinators.
Yes.
Under the joint proposal, the board would make the decision, and it would also be willing to accept the advice of attorneys and coordinators.
So which board?
The Enhanced Natural
Okay.
Resources Board,
Okay.
yes.
So there's no difference.
Oh, there is.
It's,
I mean,
There it
Well,
is.
well,
Yeah, there's, put it this way, it's, under either proposal, it's the ultimate decision maker who's making the call.
thank you.
Yeah. Exactly. In other words, the attorneys, we don't decide. The coordinators, they don't get to decide. It's the person who will ultimately, or the entity that will ultimately decide on whether to issue the permit that decides how it wants to process the permit.
Thank you.
So if you don't mind, if we could entertain a scenario under the joint proposal. So if we had a board deciding that a project is major, that's a good thing. They're holding hearings or inviting the public to participate. If they end up deciding that it's a minor, the public can still petition to have it with a hearing and have it a major.
Yes. Yes.
So the end result is the same, if the project is consequential and a hearing needs to occur.
Yes.
Okay.
There really aren't very many differences between majors and minors. It's just that the differences are pretty significant because it's whether or not a hearing is going to happen.
Yeah.
But as soon as like it's not like we have minors with hearings, you know? It's as soon as there's a hearing, the minor just becomes a major. That's just how it works.
Well,
Which is a little funny, actually, like, it seems like having a public forum where you could answer questions, which I guess the pre-application process will address, will help out, yeah. And I'm gonna ask you, Billy, if that's, what Evan just described as his understanding of how majors and minors get decided, do you agree with that from the joint proposal?
There's certainly the opportunity for members of the public, applicants, neighbors to request a hearing if something is in the first instance determined a minor. So yes.
No, I mean that it's not the district coordinator deciding if it's a major or minor, but it's actually the Enhanced Natural Resource Board deciding if it's a major or minor.
I'm looking at John right now. That may have been changed to the coordinator.
I think it was, my understanding is as a coordinator, and then,
I think it was coordinator.
and then if that decision could be challenged or.
Right. Then I think that would be I think in the joint proposal, that's the initial decision. And then any party, the board, the applicant, or others can request a hearing.
So I'm looking at page 22 of the joint proposal, lines 22 to 23, and it says the board may.
That's right, I remember the yeah.
So in other words,
So go ahead, sorry, finish the.
so in other words, if the board wants to just say, coordinators, you get to decide, it can do that. But the board can reserve that authority for itself and just say, coordinators, give us a recommendation, but we're gonna still make the decision.
And under
So it
the-
provides some flexibility.
Under this joint proposal, if someone with a particularized interest asks for a hearing, does that automatically make it a major?
No, just because someone requests a hearing doesn't mean that one is definitely gonna happen.
Right, okay, so if
Yeah.
But if it happens.
if it happens, it makes it a major.
It makes it a major, that's right.
May I ask a follow-up question? I a long time ago, I was a hearing officer for the Public Utility Commission. And when we decided, we didn't call them majors and minors, but it was really a workload decision, and some of them were obviously going to be big cases. Has there ever been, from your experience, is this distinction between major and minor and the importance of process, public engagement, has this been an issue in Act 250? Have we made mistakes in a frequent basis where something should have been a major when it was deemed a minor, or there were
Well, I'm sure that people have gotten it wrong on occasion, because that's what people do, but I think for the most part, the commissions do a pretty good job of processing applications in the right way and balancing the need to address the substantive criteria with wanting to make sure that these matters are processed efficiently and fairly. So, you know, have there been errors? I'm sure there probably have been, but I don't think that there's a notable amount of them that there's a real problem with it.
Because they can still all be appealed.
That's right.
So actually, I have a question on Carol, but, so we've heard from multiple perspectives that the environmental court, the expense and the court procedure itself inhibits appeals. I'm curious what you think of that. I mean, some people say, well, developers are putting up with conditions on their permit that are not reasonable because they don't want to take the time and money to appeal. And then on the flip side, people who are not excited that the project got approved say it's too expensive, we don't have a chance, we can't do it. So that.
Yeah, I don't know that it would be fair for me to really answer that question because it would just be based on anecdotes. I mean, the board doesn't have to.
That's all we got. That's all we got.
I mean, the board doesn't have to.
Thank you for.
The board doesn't have to pay to participate, you know, and usually when we need experts, we can tap into A&R experts or AOT experts, you know, but the first 2 years of my practice were in private practice. I remember how much I charged. It wasn't cheap, you know, and I know that engineers and landscape architects charge money for their services as well. I've always wondered what the pro se litigant feels when they show up to court and realize they have to pay their expert to present the same exact testimony that they just presented to the district commission. It can't feel good to write the same check twice. But, you know, I would suggest honestly just asking as many types of people who participate as possible what their feelings are, because they're probably going to be different than my own.
Yeah, we heard from a lot. Billy wants to add something.
I can just add, as one of the resources Evan suggested the NRB taps into, that's a significant burden on our staff and our resources who have to participate in a supporting role for the NRB on appeal de novo. So that's a very real burden on us after we've invested in the initial process.
And it's not just assisting us, but like it's very possible that A&R participated both in front of the commission and then again in the court, and so their staff are doing the same thing twice as well. And the same thing would be true with Agency of Transportation personnel or.
There were 6 appeals last year.
Right. Not many.
Yeah.
Not many.
Carol.
Yeah, so what exactly is the problem we're trying to solve? So you had to answer that question.
Yeah.
What would it be?
What's the problem we're trying to solve?
Yeah, we have this sheet. Now tell me exactly, in your opinion, from your viewpoint, what are you trying to solve?
He's not trying to solve the problem.
Well, all right, but
yeah.
you just
I
said
don't know
something
that
about
I mean, it wouldn't.
well,
Really, I don't think it would be
you
fair for me to answer that question. I mean, honestly, the board itself.
Well, what do you think the problem is that we're trying to solve? I mean, I'm
I really
trying to
like
get
closing
it.
that.
Attorney. I mean, if you.
Yeah, I
it's
mean,
totally
I
fair
would
to say
really,
that's not,
I would
I mean,
really
it's not
not
really a
like to
fair
ask that
question.
question. I mean, I really am here
We should know
representing
what
the
our
Natural
problem that we're
Resources
trying to
Board.
solve is. That's on us.
All right.
I think others who've proposed things could answer that
Yeah,
question
okay.
better than Evan. It's
All right,
not
sorry.
fair.
That's
Carrie, are you finished, Carol?
No, yes. I'll wait.
Okay, Carrie.
Oh, I didn't have a question.
Oh, Jim, somebody down there.
Yeah. So I'm still tight on this. Who decides major out of the gate? Not how it's done at this moment, but under the joint proposal of the enhanced board. And you cited a page in version 1.1 of the, yep.
Page 22, lines 22 to 23.
Okay, page 22.
It's the last 2 lines of the page. And what it means is the board gets to decide unless it takes the affirmative step to delegate that responsibility to the coordinators. So until that delegation of authority happens, and it may never happen, it might not, the board decides.
It may. The word is
That's right.
may there.
Yep.
Yep. And I'd like you to look at page 34,
All right, I'll be there in
if you would.
2 seconds. Okay,
Line 9.
yes.
Upon the application being ruled complete, the board shall determine whether to process the application as a major.
That's right.
And
That's right.
why are those two in conflict with each other?
Well, they're not necessarily in conflict. The language that you just cited sets out the default. In other words, the board's making the call. The language that I cited to says if the board wants to switch up the default, it has the ability and the authority to do that, but it doesn't have to execute that authority if it doesn't want.
I think that we took testimony and Billy just said, you know, it's their intention that they would delegate that. And I actually think that it's probably a good thing for them to have the authority and delegate it rather than saying they shall delegate it. Just
Yeah.
John.
Okay.
And it also adds the benefit of, you know, if there's, for example, let's say we hire a brand new coordinator. Well, maybe we don't want that coordinator to have that authority quite yet. We want to review their recommendations first until they get their sea legs under them.
Mhm.
Great. But you know what? This other coordinator who's been doing this 15 years, they get it right most of the time. We're going to let them make the call. It provides some administrative flexibility to accomplish additional efficiencies, basically.
Mm-hmm. Okay. Thank you.
So what Evan just said, the last thing, so as,
John, can you just say for the record?
John Groban from VNRC. So as we were drafting this, you know, we had talked about that it was important that the decisions, you know, be made by the coordinator about what's a major or minor. Two things were pointed out. So that was the understanding of the general intent. Two things were pointed out. One was that under administrative law, how you draft these things, that there needs to be some center of authority. Like if you look at the statutes now, a lot of the statute says the board shall, because the board is sort of the legal entity that's vested with the authority. And then a lot of that authority now is delegated down to the district commissions. So the comment was made, it was important to draft this to basically say the authority is vested in the board. And the NRB said they wanted this administrative flexibility that Evan just noted. So that's where some of this tension is, because when we talked about it all along, it seemed to be general agreement that most of these decisions would be made by the district coordinators, but how you draft these things, where the authority lies, and having that administrative flexibility should be in there. So I think that's what you're seeing in the words on the page. Does that make sense?
It's helpful.
Yes.
Do you
Jen,
agree, Adam,
Hall-
with
Jen
that?
Howard, we're behind, and you're patiently waiting, and I just want to check in with you. I'm fine till noon. Okay. We'll try to get you in noon. Thank you. Evan, we're back to Evan. I still have a long list, so we haven't even gone. More questions on board structure for Evan before we move on.
One quick question. Does the consolidation of districts change anything in your mind in terms of responsibility or workload?
If the commissions are eliminated pursuant to the joint proposal, then I'm not sure that the consolidation of districts will matter that much. Because, for example, like districts 1 and 8 right now have one coordinator assisting both districts, just because the volume of permit applications flowing through them doesn't warrant having 2 full-time state employees, you know? But the converse of that is District 4 has 2 coordinators because they just get hammered with applications. So the real difference now in having the administrative districts is that that's where the commissions are from. So if in the joint proposal, when we're having regional representatives sit on things, the geographic boundaries of the district is just going to influence where those representatives come from. So, for example, I know Representative Smith, I think, was concerned about Chittenden and Addison counties being lumped together. You could say, do you want someone from Burlington sitting as the regional rep for a project in, Middlebury? Maybe not. But that's probably the most meaningful ramification of how you structure the administrative districts.
Well, if I could just take it one step further, I remember earlier you testified that given the additional criteria, you expect 250 to be busy in the years ahead than it is presently.
Well, it's just any time you're adding things for a commission to review, it's gonna take a little longer to review it. I mean, it could mean that like it takes an extra 30 minutes for each application, or in one particular project, it could mean the whole project is all about that one criteria. So in general, you would think more things to review, more time, but how much more time, that's totally gonna be project dependent.
And I guess the idea is too is, would there, if you were looking at minor projects, and if the board alone was handling both minor and major, I'm not sure that's in the cards, but I'm just wondering, can you have more than one going on at the same time? If we only have a 3-member board, can we have more than one, can they be involved in more than one project at the same time?
Oh, yeah, I'm sure.
That's
Well,
what I mean.
yeah, I mean, it would be simultaneously reviewing multiple projects, but they'd be in various stages of review. But yeah, you wouldn't, I don't know that you could have 2 hearings on the same day, because you have a surplus of regional representatives to pull from, but if you only had 3 full-time members,
Right.
I mean, I guess if you were staffed with a bunch of alternates, you could make it happen, but I imagine you'd be talking about 1 hearing a day.
When you say staffed with alternates you mean to the enhanced natural resources board?
Yeah, I mean, theoretically you could do that, but then you're talking about a bunch more people. I think it's more likely you would just do 1 hearing a day. But, you know, I bet it's probably relatively rare that the environmental division has 2 trials going on at the same day. So is it really that much of a difference? Probably not.
Well, I don't know what their volume is, but, so, folks ready to shift gears to another topic? Okay. I would like for you to help us understand the capability and development plan, how it's used now, and what you and I were able to talk about this morning, a little bit about, we've made changes proposed to the findings in that. And so how does the capability and development plan play into Act 250 today, and our proposed changes to it, how would they change things?
Sure. So, right now, criterion 9 is broken out into a bunch of sub-criteria. But the very first section of it basically says, I'm pulling it up right now. The very first section of it says that the project has to be in conformance with a duly adopted capability and development plan and land use plan when adopted. That's the first sentence of criterion 9, and then you've got a bunch of sub-criteria. And then there is some statutory authority in section 6042 that requires the board to adopt a capability and development plan. Lots of people think that the legislative findings from, it was like 1976 or something like that, in which the committee is contemplating amending, are the capability and development plan, and that's not necessarily true. I think that last year there was a professor associated with UVM that provided this committee with a copy of the capability and development plan. It's pretty old. It's not really used in Act 250 permitting proceedings because it hasn't ever been updated.
It's just a couple sentences, I think. It's in the law book that I have, isn't it? Just
I haven't looked at it since I tracked it down from that UVM person last year, so I can't really remember exactly how long it is or the points that it addresses, but I just wanted to distinguish it from the legislative findings that you're contemplating amending. It is actually a separate document, but because it's old and it hasn't been updated, it's really just not used very frequently. I'm not aware of a single instance in which it's been used since I've been associated with the board. That's not to say it hasn't, but I'm not aware of it. So that's basically it. It's just
that
old and
seems like a
outdated.
pretty big disconnect if the first sentence of 9 is referring to something that doesn't functionally exist.
Yes, that's right. Yeah. I mean, I think, just sort of, from what I mean, I wasn't around when it was developed, obviously, but when there used to be in Act 250 some provisions related to statewide land use planning,
Yeah.
and those provisions were struck many, many years ago, and that statewide land use plan never came into being. And I think the capability and development plan, my understanding anyway, and I could be mistaken about this, is that the capability and development plan was really supposed to help inform what was going to be in the statewide land use plan, just as much as it was supposed to help inform commission decisions. And so when the land use planning went away, I think that the capability and development plan sort of fell by the wayside as well. So, I mean, it's something that could be updated if the legislature wanted. I think the board would appreciate, if that's the way the committee's going, I think the board would appreciate some guidance on that. And in order to get a good plan in place, I imagine it would require a lot of public process. It's not something we would just want to sit in our offices and write. I mean, we would want to have a stakeholder process and get comments and allow people an opportunity to provide input.
And then as far as your comment on amending the findings from 1973.
Oh, yeah, so that's, so there was all of these, there's all these findings from 1973, and the language is fairly lengthy and fairly aspirational. My recollection of it is it doesn't provide as concrete a guidance as the actual Act 250 criteria themselves. And currently, right now, there is, well, in criteria 9, it says that those legislative findings shall not be used as criteria in permitting decisions. And the proposal in the committee bill includes striking that sentence. And one concern that we've had is that people will infer that the intent behind striking that sentence was to make all of those legislative findings essentially additional Act 250 criteria. And they would be very difficult to implement as criteria. And so I would just urge the committee to give, if it's going to amend those legislative findings, it provides some guidance on how it intends for them to be used, because I could see a lot of back and forth argument about that.
And then your other, I mean, and as a part of that, you suggested that if we wanted to have new findings, we should just have new findings
Oh, yeah,
in
you
our
could.
bill.
Yeah,
and that-
absolutely.
yeah, so, okay. I think that's worth looking at. See what our council thinks about that. Questions about master plan permitting. And they came up a little bit this morning around with Warren's testimony, and this is another understanding the sort of cumulative trigger to Act 250 and whether or not incentives to promote master planning might both help meet statewide land use planning goals, but also help landowners not get into these situations where, like, the 10th house triggers Act 250 at the end of a road, and the rest of the development actually doesn't support statewide land use planning goals, and kind of nobody's happy in that scenario. Do you have thoughts on how master planning is used now? And there's a proposal in the joint proposal to sort of limit permit fees or have an option there, if that's going to help people be less intimidated by pursuing that earlier.
Yes, the board is hopeful that the proposal in the joint proposal will be effective. Master planning is governed by Act 250 Rule 21, and it really allows two different things. Well, I should rephrase that. Master planning can accomplish as much or as little as the developer would like it to. Because under Rule 21, which is called the master plan rule, two different scenarios on either end of the spectrum for you to consider. Someone might be thinking to themselves, I've got a piece of land and I'd really like to put my housing development there, but you know what? I know there's some wetlands, and I don't know if the wetlands alone are going to be a deal breaker for me in Act 250. So what I'm going to do is I'm going to go to the commission And under Rule 21, I'm gonna ask them to only review my project under the wetlands criteria. And that way, before I invest a bunch of time and energy on all these other criteria, I'm gonna figure out whether or not that one thing is gonna be a deal breaker for me. And if that's all the developer wants to accomplish through master planning, then they can do that if they want. On the other end of the spectrum though, the developer could have like a 3 or 4 phased ski resort or something with trails and base lodges and condo complexes and all kinds of stuff. And they know that they're gonna be developing this over like 15 years. They could go in and get master plan approval for like all of the utility infrastructure, road layout, ski lift layout, a whole bunch of components for all of the different phases. That way, maybe, you know, and they'll get that approval, and then like a year from later, when they're finally ready to break ground on that first condo project, all they have to do and go back is get construction approval. You know, and they're basically banking all of those findings for future permit amendments. In other words, do all your due diligence up front, get findings on as many criteria as possible, and then just recycle those findings as you fully develop out your project. That's like the gold standard of master plan development. And during the Act 194 working group on industrial parks, it became clear that perhaps the master planning tool was being underutilized. And it was also clear that some people didn't really understand that you could engage in this master plan process even if part of your project was already developed. So like, for example, if I've got, if I wanted to develop an industrial park and I went and got an Act 250 permit just to subdivide the lots, just to create the lines on the ground, and then I realize I'm having difficulty finding people who want to buy a vacant lot and build their new warehouse, as a developer, I might say, well, I might have an easier time marketing my lots to businesses if I can show them that I have Act 250 approval for the wetlands and the stormwater infrastructure and the road layout, maybe the size, shape, and color scheme of buildings even under aesthetics, right? The developer could do all that work up front, even though they already have an Act 250 permit, get some master plan findings, and then use that as a marketing tool for their businesses. Hey, pick my industrial park over the one down the street, because I've done more homework up front, and that's less that you have to do. So what we tried to do in the Act 194 Industrial Park Working Group is clarify that for folks, so that people realize that this was a tool they could tap into even for existing developments. And then also make it clearer how the the Act 250 permit fees are calculated, so that someone who does reach that gold standard and does all that due diligence and homework up front gets a little bit of a break later on in terms of permit fee reductions and things like that. So that hopefully those types of changes will encourage people to use Rule 21 more frequently than they do right now. So we're hopeful that those changes will make an impact. It's yet to be seen, obviously, but.
Okay. We have a couple new sections. I'm gonna go to release from jurisdiction. It's actually in our draft, 10.4.
Mm-hmm.
Have you seen that?
Yes.
How do you think that would be implemented? I mean, what would be the challenges or? It's sort of never been done as far as I can understand, and so I'm wondering, A, how the board would respond, and then your crystal ball of like, how do you see it happening? Yeah, I mean, just rereading it again now,
I think that this would be possible to implement. I mean, I imagine what we would end up having to do is create some type of application form, and then, you know, use a process, you know, I imagine what we'd have to do is create a process where someone could fill out an application that was specific to this, that addresses each of the findings that the commission has to make before releasing jurisdiction, and then create some type of process whereby all of the people who would be entitled to notice if it was an application would have the ability to weigh in on whether or not a release from jurisdiction is appropriate. And then theoretically, if the commission wanted to, it could hold a hearing on the matter and take more evidence, and then issue a written decision, which presumably would be appealable, just like other acts or decisions of the commission. So I think it would probably work very similar to an application, a regular application does now. It's just that the focus of the exercise would be different. But I think we could do this. We'd probably just have to, you know, we would have to go through the rulemaking process to create that process, and then the procedure, and then everyone would be clear on how it works. But we could do that. Go through some rulemaking, maybe do a guidance document or two for the public, but we could figure it out.
And that would be at the board level.
Yeah, this proposal has it being the district commission, but if you were to get rid of commissions, then the board could handle that.
Or even if we don't, it seems like it's a board goal anyway.
I'm sorry, what
I mean,
was-
the process you're talking about needs to be developed at the board level.
Oh, yes, yeah.
Regardless of what.
Oh, yeah, right, yeah, no, the board would be the rulemaking authority and the authority that would put together any procedures and guidance documents and stuff.
And then another proposal which we've heard about but is not in our draft is towns transitioning, or not necessarily the town's transitioning, but a development that's under Act 250 because of the fact that they were in a 1-acre town, and then their town has become a 10-acre town. How would that work? Or should it work? Or what do you think of that? Have
So
you
you
run
mean
across that?
You mean like in an extreme scenario where a town has duly enacted zoning and bylaws, so they're a 1-acre town, and then all of a sudden they decide they're anti-regulation and get rid of their zoning?
No, the other way around. So I did a development, I'm under Act 250, and my town has since become a 10-acre town. But the only reason I triggered Act 250 was because my town was
okay.
the size of the parcel.
I see, okay.
So what
happens
well,
there?
Does anything happen today? And this proposal on the table is to remove jurisdiction from that project.
I see, okay, so today, because it's already subject to Act 250 jurisdiction is perpetual, it runs with the land, so they're stuck, and anything that they do on their property would just be analyzed under the material change jurisdictional trigger. And that's how it would work, so they effectively would not get the benefit of their town being reclassified if they're already subject to Act 250 jurisdiction.
And so if we wanted to extend them that benefit after the fact.
I don't think this would do that.
No, I know it wouldn't,
Oh,
but
okay.
we're considering it, we haven't done it yet, I just didn't know if you could, if it brings up any issues for you that we might want to anticipate.
Well, that's a policy call that the board has not considered and weighed in on, so I can't offer an opinion that way. Just procedurally, I suppose I will point out that the board maintains on its website a list of all the 1-acre towns and a list of all the 10-acre towns. The board's not statutorily obligated to provide that list. It does it as a courtesy, and that list is not binding. In other words, if a town is listed as a 10-acre town, and then a coordinator realizes that's an error, they can reach the opposite conclusion in a JO. Since I've been working for the board, I have on one occasion handled a request to reclassify a town. That is not a light lift. That takes a lot of effort because it requires you to determine whether or not the town has, quote, duly adopted zoning and subdivision regulations, which means that the Natural Resources Board needs to make sure that the zoning and subdivision regulations comport with all of the minimum requirements that those regulations have to meet that are contained in Title 24, and that the proper procedures were followed for enacting them. So that requires a lot of homework and a lot of interaction with the town and a lot of review of Title 24 and someone's zoning and bylaw regulations.
And that happens today at the board, then at Natural Resource Board.
I did it, so yeah, I mean,
But that's the procedure for a town, they have to apply to the NRB.
there is no procedure. There is no procedure in statute that sets forth a mechanism for how this determination is officially made.
Huh.
Like technically, it could be made in the context of any individual jurisdictional opinion or permitting decision. It's just that because we have voluntarily taken on the role of providing this list as a courtesy, we will also, as a courtesy, welcome requests to change a town's classification. So if the town of Berlin, where I live, said, NRB, I think you've got us listed incorrectly, we would undertake it on our own to reevaluate the situation. But that's not like a process that's mandated or even really addressed at all in statute or rule. We just do it.
Carrie?
But if we had a process by which those local bylaws are approved by a regional planning commission, and part of that approval is making sure they're consistent with state goals in statute, would that approval process that illustrate and demonstrate that compliance with Title 24 would be adequate for the purposes of recognizing that that town has adopted, in your language, duly adopted those local bylaws?
Yeah, zoning and subdivision regulations. I mean, you could, I mean, the legislature, as a matter of policy, could create whatever mechanism it wants. I mean, and assign the responsibility to whoever it wants.
I mean, the reason why I ask is as a follow-up, because I think the more we enable municipalities to take on the ownership of their zoning and subdivision bylaws in a deliberate way, I think it's makes them more resilient to flooding, for example, has all the benefits of having that local authority to evaluate projects on a project-by-project basis. That's a good thing.
I'm actually thinking, oh, well, it's one more. The, we took testimony on the climate adaptation criteria that we're contemplating including. It's actually in both the joint proposal and our online bill. It's in different locations. The joint proposal puts it as a 9M.
It's a 9M, okay, I mean.
It has to do with climate resilience and siting.
Okay. Okay, oh yeah, I see it in the joint proposal.
So, how would the board implement this? I'm sorry.
I don't know,
You're very
honestly.
tolerant. You're incredibly helpful and very tolerant of our. It's just we have to we're trying to understand how things might be implemented that we're contemplating.
What page are we?
I'm
So
not sure what page it's
page
on.
47, lines 21 of the joint proposal. Honestly, I don't know how this would play out in front of in front of a permitting. I mean, this is, like I said, I mean, any of these changes, there's going to be some growing pains. I mean, we're not gonna get this right out of the gate. I mean, we're gonna be learning too, and I honestly don't know how we would go about applying this. That's not to say I'm saying it can't be applied, but you know, I do not purport to be a climate expert. I would not claim that, and so it's difficult for me to answer that question.
Do you know who you might talk to about that?
Well, I think the state has a climatologist who works out of the University of Vermont, who actually just helped significantly draft the latest climate report that was submitted to Congress. She's fantastic. I saw her present at the Attorney General's office. I would definitely suggest getting in touch with her. If you haven't already, you might have though.
Might have.
Yeah.
we've maybe talked to everyone in the state.
It's possible.
There's only 600,000 people. At least everyone over 18. Gary.
Well, I do know from just my prior experience that some of the climate adaptation is obvious, you know, making sure it's sited out of harm's way. Orientation is important for passive, but also the strategic placement of shade to ensure that you're minimizing the use of
Air
heating
conditioning.
and cooling,
Yeah.
of cooling in the summer and heating in the winter, because of that windbreak and shade value are examples of how you can really improve
Yeah.
the climate resilience of building. So, but in your opinion though, would it be helpful to keep it somewhat vague here in terms of making sure that the right knowledge is tapped into to help describe that, or because it's not really that rocket science. It's about weatherization, which we already talked about,
Yep.
conservation and efficiency. But this way it helps to hone in on using the best science and knowledge of building science to help reduce the demand on heating and cooling, for example.
No, I mean, that's certainly true. I mean, if there's always this balance between, you know, specificity and flexibility, right? I mean, the more specific something is, the more clarity it provides to people, but also that means it's more rigid. We can't adapt to it as easily. We have to come back to you to change it on a more frequent basis. Something like as general as this, you know, we would be able to flush out any ambiguities through the rulemaking process if we really wanted to. You know, there's no prohibition on, you know, on us creating through rule a definition of landscape design if we really wanted to. We could do that to provide additional clarity. You know, some of these will also be impacted by other criteria, right? We have criteria related to river corridors and floodways that are probably going to address some of the resiliency stuff. We also have 9F that talks about commercial and residential building energy codes. That might get into some of the heating and cooling stuff that you were talking about as well. And you know, how landscape design for climate adaptation will compete with aesthetics, you know, we'll have to see how that flushes out. But other criteria will also address some of these issues. What's helpful is this calls out that climate should be at the forefront of people's minds. So it's helpful, but exactly how this will play out is difficult to predict sitting here thinking about it right now.
Okay, thank you. One more before we get to Jen. I'm going to ask about permit presumptions and how we've been asked to right now, A&R permits go through a rulemaking with the NRB, and there's a request in the joint proposal that change to a presumption that, help me out, Billy.
Basically that any state permit would enjoy a presumption that they address the issues that are addressed in those permits, so they would not need to be called out by name in individual rules.
And then therefore would not have to go through the rulemaking.
Correct.
So I need to understand what the rulemaking today does and what it looks like, and then what the ramifications of this might be.
I think it probably makes things a little bit simpler. I think it probably does have some helpful aspects to it, because right now we've got the Natural Resources Board has the authority to assign presumptions to certain types of permits, and the board does that through Rule 19. What I think we noticed though is that the permits that we have today from other state entities are not necessarily, I mean, they've changed since Rule 19 was promulgated, and so there's this exercise in sort of constantly keeping up with which permits should and should not get a presumption, and it's probably always going to be a slightly out-of-date list. So I think the approach that the joint proposal takes is a reasonable one, which is let's think about process-wise what types of permits we want to get this benefit, and then just it is what it is. We don't have to worry about constantly updating a rule and going through the rulemaking process to list them all out. We can just say, if you issue a permit that engages in this process, we have confidence that there is sufficient public participation, and therefore it's entitled to a presumption. So I think it would add
So
value.
you mean in the creation of that permit, they already went through rulemaking, and but what happens today if a new rule from A&R comes over the NRB?
Oh.
What happens?
Yeah, so if, like, let's say, for example, the legislature were to grant A&R some new permitting authority, like a whole new regime that they get to issue permits for. Today, that permit would not be entitled to a presumption unless the board updated Rule 19.
How do they do that?
We'd have to go through the rulemaking process.
It's a whole other public participation process.
Yeah, I mean, ICAR, LCAR, the whole deal. We have to do the whole deal.
And how often does the board do that?
Well, they haven't done it since I've been there, but we've been waiting to see what's gonna happen, and then we're gonna do one big giant rulemaking process.
How
We're sort
long-
of keeping a bank of
How long
everything.
have you been there?
Just shy of 2 years, I think,
And
roughly.
how big is the bank of rule permits?
You know, it's like a list of 2 pages, I think, single spaced. I mean, a lot of it is, I mean, we've got some cleanup stuff to do, and you know, depending upon how things shake out, there might be a lot of rulemaking, especially if the board is hearing decisions again.
Give me an example of what's on that list.
Well, and one example would be out of the Act 194 working group, there was some proposed rule changes that dealt with how permit fee reduction reconsideration requests are made. That has to be addressed through rulemaking, so that's on our list. We haven't done it yet because we're waiting to see if the legislature is going to endorse the statutory changes that we also recommended for master planning.
But that hasn't, is that an A&R permit that's gone through rulemaking? Because that's you guys, that's not an A&R permit, right?
Right.
Oh, okay.
But I'm saying, in order for us to change Rule 19 to give a presumption to their rule,
Yeah.
we would also have to go through rulemaking. As opposed to this proposal, which just says A&R, if you guys get authority to issue a new permit, or there's an existing permit you issue, and it meets these criteria, we have some confidence in the permitting process, and you're gonna get a presumption in Act 250. That seems reasonable.
Okay, but the one that just came to mind for you was one that you're gonna have to do anyway, because it's about your fees. It's not from A&R.
Right, but it might not make sense to do it if you don't adopt the statutory changes related to master plan.
Right. But if we do, you'll have to.
Right, but that's just an example of one of the things that we've been waiting to do because we don't know what we're gonna look like in
Fair enough.
a year.
We don't need.
Yeah.
All right, I think we need to transition to Jen.
Okay.
Will you be with us this afternoon?
Yes.
Thank you for your time.
So much.